in with Mr. Sly, Mr. Anderson. Unfortunately, we just weren't able to get to common ground like we did on Senator Deeds' bill. And we do think the bill has major problems and simply doesn't work within the existing federal statute. Just as background, back in 2018, we worked with people on both sides of the issue, DEQ on Senator Hanger's bill, which really set up this whole statute. It's the most aggressive pipeline regulatory statute under this 401 in the country. And it really, I think at the time, they took the 401 statute, what states could do, to its maximum extent. It's very aggressive towards pipeline advocates. If you were doing an identical 42-inch water pipeline, for example, you wouldn't have any of this. You'd just be going under existing standards and specifications. So our application, or the application of any pipeline person, is triggered by a certification request. That's what gets the 1-year clock ticking. There is nothing in the federal statute that talks about things that have to be done prior to the 1-year clock ticking. Just as background, when MVP was put in place, we went through the certification request. DEQ then requested 8 erosion control and stormwater plans from us. That took 7 months. That was 780 pages of documents, kind of the kinds of things you'd expect decision makers would want: an upland land disturbance plan, a steep slope management plan, riparian buffer plan. There's 8 or 10 categories. What we're really talking about now are the detailed topographical maps and supporting calculations. I think Delegate Bulova is very familiar with this, that underlie the plan. Now, the way the statute was set up in 2018 is that all the true planning materials had to be done before certification, but this detailed, it's non-discretionary calculations just had to be done prior to construction starting. I think the essence of the problem with the bill is that it's trying to put forward a timeline and how the state can deny that doesn't follow the federal statute. The federal statute lays out the reasonable period of time, I think, as Director Paler said. In establishing the reasonable period of time, it talks about the factors the federal agency, FERC, can go by. And then if there is a denial, there are specific things in the statute, the reasons for the denial, or the waiver. Unfortunately, as Delegate Bulova said, you don't get a mulligan. This is a one-shot deal. And if the federal agency determines that the denial is not for an appropriate reason, then it's a waiver situation. It's not a remand back to the agency. It's a complete waiver. I've talked to 3 practicing attorneys who are experts in this area, who have each said that that this statute is not workable and the likely outcome is a waiver. One of the attorneys who worked for a developer said that might be a good thing because they would get no pipeline oversight whatsoever. But we want the statute to work. We worked on the 2018 statute. We worked with Senator Deeds on the stop work statute. So with that, I'll let Mr. Pomeroy have some remarks.
Thank you, Mr. Shinn. Mr. Pomeroy?
Mr. Chairman, members of the committee, I'll be brief, building off of Mr. Shinn's comments. We had some discussion in the testimony earlier today about the new extensive federal regulation in this area that there's obviously concern in the discussion about not getting crosswise with and walking into a preemption or waiver scenario. The point I would make about it is that in 40 CFR 121.7, there is a burden and a responsibility on DEQ should DEQ deny for lack of sufficient information. It's not a free pass for DEQ. DEQ takes on regulatory obligation to describe the specific water quality data or information that would be needed to assure the discharge for the proposed project will comply with water quality requirements. When we think about whether we're needlessly risking a potential federal waiver, I think the phrase was because there is no mulligan when a federal agency decides, we should bear that in mind, that the burden does shift in the case of a denying state agency for lack of information to specify what the needed information is. And as Mr. Shin was saying, this is extensive information when we get down to the nitty-gritty detail of hundreds and hundreds of pages of engineered erosion and sediment control plan specifications. The last thing I'd like to say, Mr. Chairman, is that the 2018 statute was negotiated to set up a very important safeguard, which remains on the nitty-gritty technical details as I referred to them, and that is, and this exists still in lines 45 and 46 of the bill, of the substitute that came over, where it says that the applicant shall not commence land disturbing activity prior to approval by DEQ of the technical plans we're talking about. So that safeguard was added in 2018 and remains. You don't need to risk the time constraints and the information risks on a potential waiver under these very new federal rules to have that protection. You have it now because no project developer may commence with construction unless and until the DEQ blesses the very technical plans, the actual technical plans that we're having this whole discussion about. That safeguard's in place now and remains in place even without the legislation. So I just wanted to make sure that you were aware that that protection is there. No one may proceed without DEQ blessing the technical plans. Thank you, Mr. Chairman.
Thank you, Mr. Pomeroy. Delegate Blox, do we have a question?
Sir, Mr. Chairman, I guess